Good morning, and welcome to the final day of the National Press Foundation's Living Longer, the New Age for Aging Journalism Fellowship. We are gathered here this morning after 2 days of really intensive yet evocative conversations about the 55-plus worker demographic. I think we've learned a lot about how not to categorize them, how not to put them in a box, how to think about supports and how to think about the resources that older workers need, but also about the ways that supporting the older worker demographic benefits the entire country and all age groups in general. We are here this morning after a really robust conversation last night about the issue of artificial intelligence and how it is impacting older workers and their lives and their pursuits. And so now, this morning, we'll get to explore even further and mine that data and that information even more, because we'll be hearing from Raymond Peeler. And Raymond is the Associate Legal Counsel with the Equal Employment Opportunity Office. And he'll be here to talk about artificial intelligence and talk about initiatives and objectives to sort of change the way it operates. So, Raymond, please take it away.
Good morning, everybody. Thank you to the National Press Foundation and AARP for inviting the EOC to participate in this important effort that delving into a real cutting-edge employment issue. And congratulations to all of you as fellowship recipients. What I'd like to do with my presentation is sort of split it into kind of two chunks. And first, I want to talk about the EEOC's role. For those of you who may cover employment law regularly, this may be a little bit of a review, so please forgive me. But I think it's important to make sure everyone understands how the EEOC comes to address AI and to understand the lens that we use when we are reviewing AI and employment decisions. So the EEOC enforces several federal employment non-discrimination laws. There's Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, sex, which includes pregnancy, sexual orientation, and gender identity, national origin, and religion. And it requires reasonable accommodation for sincerely held religious practices or observances. We've enforced those laws since the EEOC's founding, and one sort of interesting bit of Title VII related to older workers is that you can have a sex plus or a race plus claim under Title VII. So it's possible to have a claim where maybe not all women are affected, but there's evidence that older women are being treated worse in the workplace, and so you can pursue that under Title VII as well as potentially under the ADEA as an age claim. So you can Title VII can be relevant in this context. EOC also enforces the Americans with Disabilities Act of 1990. The ADA prohibits discrimination against individuals with disabilities, and it requires employers, upon request, to provide qualified individuals with a reasonable accommodation to apply for a job, to perform the duties of the job, or to enjoy the benefits or privileges of employment. The ADA does not apply to the federal government, but Congress applies essentially the same standards to federal agencies under another statute called the Rehabilitation Act, 1973. This statute, I think, is particularly relevant for older workers in the context of as people age, being more likely to develop disabilities. And so you can have an employment decision that adversely affects people because of a disability that can also have an adverse impact against older workers. It's more likely to harm older workers, while it's also has an issue under the ADA for disability discrimination. We also enforce the Genetic Information Non-Discrimination Act of 2008, or GINA, which prohibits discrimination based on genetic information, which includes not only the results of genetic tests, obviously, but also family medical history. So there's 6 narrow exceptions when employers can collect genetic information. It imposes some confidentiality obligations on employers who have such information. The ADA, by the way, also has a confidentiality requirement for disability-related information on employers. The Equal Pay Act of 1963 prohibits discrimination in pay based on gender for workers performing substantially equal work under similar working conditions. And then finally, most relevant for our discussion today, the Age Discrimination in Employment Act of 1967, or the ADEA, prohibits discrimination based on age for workers who are at least 40 years old. Unlike the other laws that the EEOC enforces, the ADEA is a one-way ratchet, meaning that it is not unlawful under federal law to favor someone in an employment decision because of their older age. It is only unlawful if it disadvantages the older worker relative to their younger counterpart. Now that's federal law. There are some state laws that do not allow considerations of age in any context, but under the federal law, any thought of age or inclusion of age in a decision isn't necessarily discriminatory. You have to look at whether that inclusion of age as a factor in their decision is disparately affecting the older workers as opposed to the younger workers. Generally, the ADA does not allow mandatory retirement ages for employees, except for executives and high policy-making officials. There's exceptions for firefighters and police officers. That said, the ADA does include a bona fide occupational qualification, or BFOQ defense, which in some very limited circumstances allows employers to prove that using an age cap is reasonably necessary for the normal operation of that position. The classic example is airline pilots who, by FAA regulations, cannot fly commercially after the age of 65. And so you have to be under 65 to become a pilot. That's a BFOQ. And so I bring that up because one element of AI is these screening protocols. A employer may have a chatbot or some other program that is asking questions regarding someone's age, and in those very, very limited circumstances, it's not going to be discriminatory if that AI screens those people out if age is a BFOQ for that position. But if they're doing that for any other position, then that's going to be a problem under the ADEA if they're screening people out due to their age or due to their advanced experience. Generally, these laws apply to employers with at least 15 workers under Title VII, the ADA, and GINA, or 20 workers under the ADEA. Why 20 instead of 15? I don't know. That's what Congress said. They also apply to labor organizations, federal agencies as employers, and sort of most relevant for our conversation, employment agencies. And I want to talk about that a little bit later. I want to hold how that's particularly important when we're talking about AI. So those are the laws that make up the EEOC's enforcement authority. And then very briefly, I want to talk about how we enforce those laws. So before anyone can file a lawsuit under any of the laws that I mentioned, except for the Equal Pay Act, first they have to file a charge of discrimination with the EEOC. Generally speaking, the charge has to be filed within 180 or 300 days of the alleged discrimination, depending on the jurisdiction. And the EEOC investigates those charges, and generally we're going to try to encourage settlement during the course of that investigation. At the conclusion of the investigation, the EEOC is going to make a determination of whether we believe that reasonable cause exists to support a claim of discrimination. If we find cause, then we will attempt one last time to resolve that dispute between the employer and the employee through a process called conciliation, which is statutorily required under the laws that we enforce. If we can't resolve the charge, then the EEOC we're at a decision point. Are we going to file suit in the public's interest, assuming it's not a state or local government under Title VII or disability laws, in which case that decision is for DOJ to make and not us. But for private employers, are we going to file suit? Or are we going to give the the employee a notice of right to file a lawsuit on their own. So if we don't find cause, charging party still gets that notice of right to file. Our findings are not definitively saying that no discrimination exists, but rather that in the course of our investigation, we didn't find that it was supported. Charging party can always still file a lawsuit where we've not found cause, and even if we've dismissed the suit. So the EEOC's failure to find cause does not extinguish the charging party's right to seek resolution in court. There's two different main theories of discrimination that we use that, and their differences, I think, really become relevant when you talk about AI, particularly when you're taking the human portion out of the decision-making process. The first is called disparate treatment discrimination, and there's an element of intent in disparate treatment discrimination. The employer is intending to use the protected basis in their decision-making. It's often proven when evidence, the employer will say that they have a non-discriminatory reason, and there'll be evidence to undermine that, and so the decision will be made that, well, then the discriminatory reason must have been the real reason for their decision. So it's kind of rare that we have, smoking gun, the employer saying, I'm trying to get rid of the older workers, and so that's why I'm employing this thing. But you get to it in a roundabout way by showing that the rationales that they have provided aren't true. So the second method of proof is called disparate impact discrimination. Here there's evidence that regardless of the intent, doesn't matter whether the employer was trying to disadvantage older workers in the situation, the decision-making process disproportionately, adversely is affecting the workers on a protected basis. The cases are usually proven using statistics to show that a particular group is adversely affected, and the employer is then liable for discrimination unless they can meet a defense. The defense differs depending on the statute that's involved. For Title VII cases, one of those cases where there's sex plus age, for example, the employer has to show that their decision is a business necessity. So if there is any less discriminatory way for the employer to achieve their non-discriminatory goal in this process or procedure that they put in place, then it is unlawful and it creates a disparate impact. The standard for age discrimination is a little easier for employers to meet. The employer only has to show that the decision was based on a reasonable factor other than age. Courts have explained that this definition does not have to be the least impactful method for achieving its means. It just has to be something that appears reasonable in the normal course of business. So I bring these up because in the context of AI-based decision-making, it's often not clear what factors are being considered in the decision. It's very unlikely that there's going to be evidence that the employer relied on the AI decision-making with the intent of not hiring or limiting workers in a particular group, although we've seen a couple of those. I'll talk about those in a minute. When we're talking about proof with age claims, there's one other concept that I want you to think about, and that is decision points that are a proxy for age as opposed to those that are correlated with age. So employers may say, well, I didn't make this particular decision because of someone's age. The factor that I considered was whether they were Medicare eligible. Well, of course, if you're 65 years old, you're Medicare eligible. That's proxy for age. But a decision that's correlated with age is something that is more likely to impact older workers if it's used in an employment decision, but it's not necessarily defined by age. Physical or health metrics, for example, gaps in resumes may be something that is more likely for older workers. There are lots of things that can be correlated with age, and would be very difficult to prove intent there, where there's just a correlation. Unlike a proxy, you can have intent there because they're using something that is directly age-based. So in those cases, often the plaintiff's attorneys, the EEOC, if we're pursuing the lawsuit, are going to be looking at disparate impact claims. If all that we have is some factor that isn't age, that's correlated with age that the employer is using for their decision. Kind of, when we talk about this correlation with age, the most concerning piece from my perspective are employers seeking to find particular traits in workers that in the traditional workplace situations tended to be defined by age-based stereotypes. So how does the employer, and now an AI algorithm or testing protocol or whatever, determine its most flexible employees, its most energetic employees, who's the most technically savvy employees? Does involving AI change the underlying stereotype rationales that employers have used to assess these traits? I think the devil in those situations is going to be in the data. Before I really sort of move on more to talking about AI and our initiative, I wanted to give you guys, if you have any questions about kind of our basic enforcement authority. Nope, okay, moving on. So what does AI mean to the government? So Congress defined it in the National Artificial Intelligence Initiatives Act of 2020 as, I'm going to read this off, a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. That said, I think companies are also using AI as kind of a marketing term. You know, we use advanced AI for our thing that you can buy from us. And whether or not, for EEOC's purposes, a technology fits this definition that's been laid out by the statute is really not important to us. We're just looking at the legal analysis for whether or not age was the reason that the employer made the decision that they did, or did they use some proxy for age, or is there evidence that whatever factor they're using is disparately impacting older workers? That's what we're going to be focused on, regardless of whether the program that they use is something that's going to meet this statute's definition or not. So these systems run on algorithms. I'm sure you guys have heard this bit, which are sets of instructions for a computer to accomplish some end. Another term that we hear is machine learning, which to our minds refers to the ability of the computer to change its algorithm in response to the data, to learn things on its own. But really boiled down to its most simple, the AI tools are attempting to identify patterns to aid or even replace human decision making. A few examples in the really vast array of technologies that they may use could include algorithms that decide who sees which job advertisements, resume screening tools that prioritize resumes containing certain keywords, chatbots or virtual assistants that ask about applicant requirements and screen out those who don't meet the predefined requirements so that a human never sees that application. How long ago did you graduate? Can you stand for 4 hours? Explain this gap in your resume. Tests for personality, job or cultural fit, whatever that is, aptitude or game performance, values, tests for neurocognitive traits like attention to detail, focus, risk tolerance, things like that. Some employers are actually using voice recognition or analysis to make sort of personality judgments about workers. They'll do a video interview and then they'll run it through a program and decide whether or not they want to put you at their customer service desk based on the AI's definition of whether you seem cheery enough or whatever factor it is that they've programmed the AI to look for. And facial recognition technologies for similar purposes. Advocates for these technologies stress its promise to remove the bias in the subjective decision-making that people insert into employment decisions, to handle large volumes of information, such as thousands of resumes for one job, which is a problem that employers are grappling with, more efficiently and more consistently. They claim that AI is the solution for removing unlawful discrimination from decision-making. And at EEOC, we think that's a great goal, but it's going to depend on how the algorithm is designed and what data it's fed. So ultimately, the AI is just making correlations. It's that word again. Courts have used as a term of art in age discrimination cases. Correlations, of course, shouldn't be confused with causation, particularly depending on the data that the computer's been fed to study. It might make associations that are merely coincidental, or even worse, which reflect biases that already exist in the data that they use to create the algorithm or to have it perform its machine learning. So the first point about coincidence, I did a quick Google search for spurious correlations, and you can find all kinds of fun stuff. So, for example, it is true that the rate of measles cases in the United States and the marriage rate have declined at almost exactly the same rate. Does that show that one caused the other? No, I don't think so. Video game sales and nuclear energy production also follow very similar rates of increase. More commonly, AI systems, including those that are provided by vendors, first they go through a setup process where they feed it information about the employer's current workforce, particularly if they're doing screening to try and find, the best candidates. And they ask the employer to rate their workers' performance. Who are your best people? And we're going to feed it into our machine, the information that you have on those people, and then we are going to find you more people that are like them. It's using correlations. It calls through the data to find who fits that profile, but what if your workforce isn't diverse? Do you have accurate data on what the high performers from other races, genders, or ages may look like? Are these correlations being made if the workforce has all young workers? Are they really related to work? Or does it just happen to be that because they're from kind of the same generation, they grew up in the same circumstances, that they have these things in common? But even before we talk about these sort of looking at the people who are in the door, having gotten their applications to the system, AI can play a role in whether older workers can even find out about a job vacancy existing. Employers have always considered, how am I going to reach my target audience when I'm doing job advertising? Do I want to put it on this radio station that has this particular demographic? Am I going to go to college campuses to try and recruit people who are straight out of school? Am I, going to use certain terms to try and, looking for energetic, fun-loving employees who that may insinuate certain preferences? EEOC regulations have long taken the position that employers can't use terms in their help wanted ads that seek boys and girls, youth, young workers, similar terminology that is going to make an older worker seeing that job advertisement say, well, this clearly isn't for me, and they're not going to consider me, and they won't take me seriously. But older workers used to still see those advertisements, except for maybe if it was on a college campus, and they could apply. Now, however, advertisements on social media can pinpoint specific audiences and exclude the others with amazing specificity. Even if on your social media profile you don't include your race, your age, other demographic information, or protected bases, it is likely that that platform already knows this information based on the thousands of data points that it's already collected from you. This is the entire marketing model for companies like Facebook and LinkedIn. Come advertise with us because we can get you straight to the people who are most likely to buy your service or to be the best applicants for your position. There's nothing unlawful with a manufacturer saying, well, I want to look for a particular age demographic to sell my shoes to. But it's quite another thing for an employer to do it. Ultimately, though, the temptation was a little too great for some employers, and some sought to target advertisements on social media platforms on ways that violate EEO laws. I think it's one sort of important point that the EEOC is really trying to get across when we talk about AI is that these laws, even though a lot of them were written in the 1960s, they still apply when you are making employment decisions, even though AI is such an emerging new technology. So in 2017, ProPublica and the New York Times did a report about dozens of employers using Facebook advertising targets to limit its help wanted ads to particular age groups. They also were doing it for housing and real estate advertising on the basis of race. This was really very important work, and I want to take a second to sort of highlight your role as reporters here. EEOC is a charge-driven agency, so we can only do an investigation on a matter when we have gotten a charge from the public. So if a member of the public is not bringing an allegation about the conduct to us, we can't address it. As reporters, you can do the type of research that gets that information out into the public, stretching beyond the EEOC's statutory authority. And here, after these reports were published, were by ProPublica and the New York Times, we started getting charges. Surprise, surprise. It was great. In March 2019, Facebook, without admitting any liability, settled a bunch of charges by agreeing to pay $5 million and taking steps to ensure that employment advertisements did not allow targeting of audiences on a protected basis, including age. Legally, this case raised a really interesting question. Sorry, I'm an attorney, and this is kind of my nerd moment. Of course the employer can get sued, right? The employer was the one who went to Facebook and said, I only want to look at this age demographic. And I know you can do that because it shows that in your system. What about Facebook? They an employment agency under the EEOC enforced laws? So the ADEA defines employment agency as any person regularly undertaking, with or without compensation, to procure employees for an employer and includes an agent of such person. Kind of the way that we've traditionally thought about this before these platforms. Newspaper want ads, not an employment agency. They're just reposting this advertisement. It's going out to everyone that subscribes to that newspaper or buys it on the corner. There are not decisions being made about who sees it and who doesn't. But what about now with these platforms that are making decisions about who sees the advertisement? Are they steering candidates to these employers? Do they potentially become employment agencies that are covered by Title VII? Legally, we don't know the answer to that question, because when it came up in these suits Facebook settled, they argued very vehemently that they were not employment agencies, and then they said, before the court came to a decision, here's $5 million, let's make this go away. We don't want a decision on this. So one result of that settlement, employers can't target ads explicitly using age, race, or other factors. But sort of looking forward, they cannot afford and likely don't want ads that go to an entire social media platform. These are worldwide platforms. So if they do an ad buy for X number of users to see an advertisement in Y geographic area, the platforms are still making AI-based decisions on who sees that ad. This is sort of even more so when you talk about things like LinkedIn, Monster, Indeed, these programs which are running analytics on all of their users' information and trying to link that information into the help wanted ads that they've gotten from employers to identify who's the best fit. Do those then become employment agencies? We don't know, but legally we don't know what the courts will do with that. But I think that is one sort of big issue to be decided. Another concern about the use of social media in job advertising is that older workers are less likely to use social media accounts. So employers may largely exclude some older workers from seeing the job by only advertising it on a social media platform. And then what about which social media platforms they choose to use? My college and high school age children tell me that Facebook is only for old people. But what if they decide to advertise on TikTok or Instagram or whatever it is that my kids have downloaded this week? I'm not going to see that advertisement for sure. Before this big study of Facebook advertising, EEOC sort of gradually had its attention moved towards AI in employment decision making. So on March 12, 2014, the EEOC held a commission meeting on the use of social media in the workplace. One of the invited panelists was Jonathan Siegel, who was speaking on behalf of SHRM. He referred to a 2013 study done by SHRM that at that time 77% of employers were using social media to recruit for specific jobs. The panelists didn't really delve in that meeting into AI and employment and the analytic tools that are being used and that sort of thing. But social media platforms are all using AI in deciding who sees what information. And so all of those employers are using AI in their recruitment process by putting their advertisements on those platforms. On October 13th, 2016, the EEOC held another commission meeting on big data in the workplace. Panelists delivered really sort of wide-ranging discussion on how the use of data through predictive analytics is being used in the workplace in a whole variety of settings. I encourage you to sort of take a look at that. While I've been trying to highlight discrimination concerns that may arise through AI, I also don't want to give the impression that the EEOC is opposed to its use. The overarching position of the EEOC is not to stop employers from using AI. We recognize it's already there. We recognize employers are getting, and in fact, we're experiencing this too, you may get 1,000 resumes for one job opening. And how in the world are you going to get through that? And I understand that for some employers, they would wish to only have 1,000 resumes because they have tens of thousands, hundreds of thousands of resumes coming into them. And how do they cull that down to a manageable number to decide who they're going to hire? Instead, our focus is on applicants, employees, and employers, and technology vendors too, ensuring that AI technologies are used fairly and consistently with federal employment discrimination law. So when I talk about fairness, from EEOC's perspective, when we talk about fairness in AI, we're talking about ensuring that the tools are not doing something that violates the laws that we enforce. And that position really fuels the Algorithmic Fairness Initiative, started in this administration. The initiative has 3 overarching goals. The first is to gather information to spot key issues. We're really still trying to wrap our arms around this issue and how the laws that we enforce are implicated. We want to engage with all the relevant stakeholders, including the vendors, including employers, including civil rights groups, employee rights groups. We want to identify, and third, we want to identify promising practices in the development and use of AI in employment decisions. So In this initiative, we've started working with a few other federal agency partners, including OFCCP, the Office of Federal Contract Compliance Program. Sorry, I'll try not to be too acronymy, but it's a hazard of being a government employee, which is part of the Department of Labor. And they deal with employment discrimination among federal contractors. So any employer that's a federal contractor has to answer to OFCCP and potentially also Eeoc, depending on what's going on in their claim. OFCCP has some additional authorities that we don't. All of the federal contractors have to draft affirmative action programs, provide those to OFCCP. They can do audits of federal contractors, whereas we are, again, a charge-driven agency, and we have to wait for a charge to come in before we can do an investigation. So there are some differences in how we operate. And we've also been consulting with the White House's Office of Science and Technology Policy. We launched this initiative for a few reasons, some of which are probably apparent from the discussion we've had so far. But the pandemic has really led to developments in technology and workplace change. AI is being used in recruitment. It's being used in job advertisements, in screening, in interviewing, even in candidate selection. Recent research has indicated that 99% of Fortune 500 companies are using some kind of automated tool to screen and rank candidates for hire. Candidates are typically not receiving any information about why they were screened out, making it difficult to challenge a decision as discriminatory. So, we need to think about addressing the issue of potential discrimination at the front end in the creation of these AI programs. It's going to be very difficult for employees to have any idea whether they have something worth bringing in a charge to the EEOC. Some AI is being sold with the promise that it's going to remove bias from the decision making. I heard anecdotally just the other day from an attorney in private practice that they have seen claims from some of these vendors that their program is EEOC certified. We do not have a certification process for anything. It doesn't exist. They may be talking about having performed a validation study. And we have rules, uniform guidelines for employee selection procedures, UGESP, that are from 1978. They way predate AI decision making. But they talk about disparate impact discrimination, and they were looking at, this was really when employers were starting to use like personality tests and stuff like that for the first time in the workplace. And so we, together with the DOJ and the Department of Justice and the Department of Labor, put together these rules that set out testing that employers could perform excuse me, on their selection procedures to see whether or not they had a disparate impact on, really it was targeted at Title VII, race, sex, those sorts of things. And so perhaps that's what they mean when they say it's EEOC certified, that they did some kind of validation study. AI is increasingly being used to manage employees and to monitor productivity. And from our experience, it appears that there's some confusion about if and how the EEO laws may apply to AI decision making. And I know I've said this before, but this is a point that I do want to repeat, that regardless of whether the company is developing the AI itself, uses an outside vendor, it's going to be responsible under the EEOC enforced laws for the decisions that it makes in employment. And so to say, well, I don't know, I put it into the machine and then the machine told me to hire Jeff. is not going to be a non-discriminatory rationale. They have to explain to us what decisions were made to show that Jeff was the best candidate. So what are we doing with this initiative? We're meeting with interested groups to gather information on how AI is being used and what promising practices may eliminate or at least reduce bias in its use. EOC leadership has spoken to employer groups, they've spoken to civil rights organizations, and they've also reached out and had conversations with AI system vendors on this topic. We're looking internally to create staff training to ensure that investigators have tools needed to identify and address AI-related bias when it may arise during a charge investigation. And Chaparral has also focused on developing concrete suggestions to help employers and employees reap the potential benefits of AI while still complying with civil rights laws. In May of this year, we issued 2 technical assistance documents pursuant to this initiative. One is the Americans with Disabilities Act and the use of software, algorithms, and artificial intelligence to assess job applicants and employees. And the other one is a much shorter, sort of 1-page front and back, tips for workers on disability discrimination and the use of software. We're continuing to look at this issue through the lenses that the EEOC has: age discrimination, race discrimination, sex discrimination, disability discrimination. Although to this point, the only documents that we have issued looking at the topic are on disability. Looking at those documents, there are a couple of concerns and promising practices that were identified that may relate to older workers. Time tests that have to be taken online on keyboards where typing proficiency is not required for the job. So what if a worker with arthritis, a condition that becomes more common with age, or someone who doesn't know how to type quickly because they grew up in a time when everybody wasn't on a computer all the time, can't finish the test in time and they get screened out due to their lack of keyboard or computer skills and not their proficiency, whatever the substance of this test was about. If arthritis was the issue, the employer may have an obligation under the ADA to provide a reasonable accommodation for the test, to provide some other way for the employee to prove their proficiency. But we also want employers and vendors to start thinking about these types of potential barriers when they don't relate to job performance. What is it that I'm really trying to test here, and are there other ways that I can test it? Can I have some alternative formats for people to be able to perform this test? Another one is software that's measuring productivity based on keystrokes or other factors related to computer usage. As an older guy, there's some things I just like to do on paper. I prefer taking notes on paper with a pen. I see a bunch of you guys here. Some of you have your laptops out. So if I'm working at a job that is monitoring my computer usage to decide whether or not I'm being productive, and I spend an hour and a half without touching my computer because I'm taking notes, am I then deemed to be unproductive in that workplace?
You just touched on something that I think is at the root of this, and that is, how do you monitor whatever it is that a company is trying to look for, or what they're trying to target, or what they're trying to determine, and then from your position as a policy organization, how do you make people look for the right things? How do you question that? And so I wanted to open this up to the journalists, because as you ask your questions, I want you to think about your audiences. and think about the people you write and produce for. How much do they know about this? Because I'm frankly scared to death now. When it comes, if I lose this job, man, I'm screwed. Because whatever it is that they're looking for out there, the whole universe of possibilities is frightening. So let's keep that in mind as we ask our questions. Bill?
Yeah, is this on? Yeah, good. Bill Cole, Associated Press. I was struck by what you were mentioning about the process where you're encouraging, I guess by statute, cases to settle. And then some cases go forward and you take them on. I'm just curious how many actually ever go to prosecution. You mentioned Facebook. In that case, a $5 million settlement, so Facebook wanted it to go away. How many companies are just paying some money in order to make it go away? And do people ever go to jail for this stuff? 5 million sounds like a lot of money, but if it's spread out over a whole bunch of employees, maybe it's chump change.
So the encouragement of settlement is a statutory requirement. EEOC is required to try and resolve these cases and to avoid litigation. It's conciliation is the last step before we go into a lawsuit, and it's something that we are absolutely statutorily required to do. As a factor of managing our workload, because the EEOC is seeing, depending on the year, anywhere between 60,000 and 100,000 charges of discrimination a year. We're also going to encourage settlement where we can to try and resolve the case. For us, a good resolution is where the employee receives something for their claim, and in particular, we look at policies, practices, whether the employer is willing to make changes to the way that they're operating is a really important point for us for agreeing to settle. Trying to think about what else was. That was a very dense question. Jail time. No. This is civil statute.
Okay. Rebecca.
Hi, Rebecca Knight, a Business Insider. You talked about how because of the lack of information about why an older worker is not getting the job or getting screened out, they can't tell whether or not age was the issue. And based on my inbox, my email inbox, the problem is rampant that a lot of older workers aren't getting jobs and they don't know why. They have a hunch it's age discrimination. So if I were to write an article about how to know if you're being discriminated against based on your age, what kinds of things can I put in that article?
Wow, that is a difficult question, and I think the EEOC struggles particularly in the context of hiring, as opposed to someone who's already employed, where it's a lot easier for us to get information about what factors went into to an employment decision. And the particular difficulty is if you don't know anyone else that's applied, you don't know if there is some sort of trend involving the older workers not getting the job. I think that's all information that, if you have, is certainly relevant to know. How closely do your qualifications line up with this position? Does this seem like the sort of position where you would think, well, at least I should get an interview in this? Is this the kind of position where typically the sort of an entry-level thing where the employer is going to talk to everybody or most everybody, then creating some feedback. Sorry, losing my train of thought from the buzzing in the background. So if the employer is usually going to be hiring, or maybe not hiring, but at least talking to everybody that's making a decision, and you don't even get that courtesy. I think those are all things that may make you think about why the employer may have made that decision.
You mentioned other ways to test performance, and that hit with me because, like other states, we have a workforce shortage, but it's pretty critical. We have a very rapidly aging population. So I'm wondering if you're seeing any changes in some of these questionnaires, because companies want to get people who will fit in. And some of the questions are skewed to that, like people like me who went to an Ivy League school or who have a PhD, but those aren't requirements for the job. So how do you get those things aligned? And is it pretty much up to the state level to do it, or is EEOC trying to get some changes?
So the question of qualifications is a thorny one, I think. There are court cases that have found that refusing to hire someone because they are overqualified, for example, is not discrimination and is a legitimate non-discriminatory reason. And so, it certainly is an issue that we know is impacting people on a protected basis. But to get to that directly, other than when you can get statistics together and have a disparate impact claim, I think is quite difficult because of just the way that the law stands right now.
Lauren Mapp, San Diego Union Tribune. I was curious if you know what % of complaints are AI related each year, and maybe a rough number of how many of those are.
I don't. Victor, do you know that?
Karen.
Thank you. Hi, Karen Michelle, Public Radio. I work primarily with the creative sector who don't have employers, and yet dancers, people in theater, artists are frequently laid off due to age discrimination, as well as sex discrimination, gender discrimination, lots of things. Do they have any recourse to the EEOC to file a charge without a formal employer?
So the laws that we enforce only apply to employment relationships. And so you have to have that relationship in order to be able to pursue a charge.
If they have a contract for the work, would that mitigate
so
that
it depends on the terms of that contract and whether the employer has set it up in a way so that they are clearly not the employer. We are just having this contractor come in and do work for us, or are they controlling the means, the manner of the work? Are they providing all of the equipment that's required for the work? How are they being paid? Are they paying them, here's the lump sum under the contract? Are they providing them more on like a salary basis? Are they making deductions out of things? There's a whole list of factors that we have to look at to decide whether or not there's an employment relationship involved.
Hi, Susan Tombor with the Detroit Free Press. I have a question. Many years ago, the help wanted ads in the newspapers could say things like female and male jobs,
Yes.
and they could list that way. What you raised about TikTok brings that back to me, because it seems like you're categorizing, once again, a young a person looking for a job. It doesn't have the same label as male and female, but it
Right.
certainly has a label of young person only, needs apply. Is there a way to address and to make employers go out to a broader media, or not focus only on a media source that targets young people?
So, yes and no. The employer is going to have to, well, if a claim is filed because someone's not finding out about in a job that they might be interested in or that they would be well qualified for. They would have to show evidence that the way that the employer is advertising is excluding and perhaps intentionally excluding older workers. And so, there certainly have been cases where there's evidence that employers saying, we only want to use these sources because we only want to get younger workers, and so now they've just made, you have discriminatory intent. But, finding that evidence is not easy.
Any more questions?
Hi, Monica with HuffPost. I have a question on are there beyond the job ads, which I've heard a lot about?
Yeah.
Where are you seeing claims come from that are older worker and AI related?
I'm not sure to be honest with you off the top of my head. Certainly we have seen it in the context of hiring. I would say that that's been a particular emphasis of the EOC because we know that it is such a hard nut to crack. That's something that we do want to focus on. I do also want to highlight another resource that might be of interest to you guys, available on YouTube. There's another initiative that the EOC is undertaking with OFCCP at the Department of Labor that kind of overlaps with the Algorithmic Fairness Initiatives called the Hiring Initiative to Reimagine Equity Hire. On September 13th, we hosted a discussion entitled Decoded: Can Technology Advance Equitable Recruiting and Hiring? It can be found on the EOC's YouTube account, so I would encourage you to look at that. I don't really have any information about what we're seeing in particular charges as they're coming in the door. One reason for that is issues with tracking, what's an AI-related claim versus what isn't, and also we have very strict confidentiality obligations in the charges that we file, and the charges that are filed with us, I should say. We're not allowed to provide details about respondents and that sort of thing. Where I can talk about the Facebook charge because that's in the media already, and I would, and I should probably also point out on that one that lawsuit was brought by, not by the EOC, but by a law firm and by the Communication Workers of America.
Victor, could you send us information about this agency? Any more questions before we, yes, Renee?
Hi, Renee Cordes from Mainbiz. A couple of questions. One is, at what point do the cases that you're pursuing become public? Because you talked about a multi-step process, the charges, and then whether you go forward. At what point does that become public information? And are there, sort of statistics and data on your website about how many cases go forward, how many are resolved? You said you didn't have that right away, but, can we look that up? I'm also curious to know, do employees have the right to ask their employers, if they're using AI, if they're being monitored, and can they be forced to disclose that information, or does the employee have to go, and file a suit? And you were also talking about these various fairness initiatives, but the federal law, that enshrines various rights go back decades.
Yeah.
So is there any sort of move to, introduce anything into federal law, or is it impossible to keep up with the technology advancements because, it's changing faster than you can pass laws?
Okay. So on confidentiality, we're not allowed to provide information until a lawsuit's been filed. So when it's in the charge process, we can't talk about it. We can provide statistical information. I'm not aware that that information is broken out by charges that involve AI. I don't know that we're tracking that specific marker or not. Victor's shaking his head, no, we're not. He's from our communications office. technology and the law keeping up. So I think that's really a question for Congress. We're an enforcement agency, and so we're focused on trying to apply the laws that are within our statutory authority to these new situations as they arise. And that's something that we've been doing since 1965 as new issues crop up. But as far as whether there would be or should be changes to the law itself, I think I'd have to leave that to Congress to discuss.
There aren't any more urgent. Oh, yes, Tony, you'd be the last question.
Tony Hicks with Bay City News. So I think Renee just pretty much asked the question I was going to ask about publicly accessing these cases. So in a practical sense, I mean, how do we do that? Do we have to go, like any other civil suit, go down and look it up and get the filing itself? Is there any other indicator that an action is happening to where we can go find it, other than, hoping we get a talkative representative from your organization and, hey, has anybody filed any complaints this week?
So on the filing of complaint, if you ask someone, has anybody filed any complaints, I would really hope that the answer to that question from an EEOC employee would be, I can't give you that information. And the reason for that is because there's actually criminal penalties for EEOC employees to disclose information about charges that have been filed. Now, lawsuits is a different question. When a lawsuit has been filed, typically the EEOC is going to put a press release out about that. And so one place that you can look for that is in the EEOC newsroom, curated by Victor's team, that will have some reference to whenever we're filing suit. I feel like there was another part to that question that I haven't answered, but I can't think of what it was. Did I miss something?
Well,
Pacer would be, yes, Pacer would be another way that you could find that information.
I'd like to ask two favors of you before we let you go, and that is, there was so much information in your presentation. Is it in any way in slide form, or if you give it to me, I'll put it in slide form? We would love to be able to share that with other journalists.
I can send you links to a lot of the resources that
Well, that would be great.
Yeah.
That we also do that as well. Okay. And then for Victor and you both, as press releases related to this, as initiatives and things advance, please let us know, because there's a WhatsApp group for this cohort of journalists, and we want to keep them aware and alert of what's happening as well. So please keep us in the loop on that regard. But you've given us all a lot to think about, and we really are grateful for your participation today. So let's show Raymond our appreciation for joining us. Thank you so much for being here today.
Thanks for having me.